Thank you, Connie. I'm just going to get my slides up here and I'm ready to go. Okay, so I'm going to speak to you about Ireland's premier surrogacy proposals from 2014. The proposals contained in what was the general scheme of the Children and Family Relationships Bill. Those proposals were of course scrapped when that was later revised in late 2014. I've titled the paper Too Much Too Soon because I believe that those proposals were too much too soon and were somewhat ill-considered, and I would hope that we can move towards better proposals in the not too distant future. I'll just explain to you what the general scheme proposed to do. So part 3 of the general scheme of the Children and Family Relationships Bill, it was going to be the first legislation to regulate surrogacy in Ireland, if enacted. It proposed to adopt what we call the post-birth parental order or transfer of parentage model in relation to surrogacy, such that the child is born to the surrogate who is its legal mother, but following its birth there can be a transfer of parentage in favour of the child's intended parents or the commissioning couple. I'll explain all of these terms as we proceed. The intended parents or commissioning couple are the parents who put the whole arrangement into place. So a commissioning couple commissions a surrogacy arrangement. They are the couple who ultimately intend to parent the child or children born as a result of surrogacy. And they enter into an arrangement with a surrogate, which can be, as we know, a traditional surrogate who uses her own eggs, or a gestational surrogate who carries the child for them. So she will use basically an embryo formed from the genetic material of others. In the not uncommon example, it can actually be both members of the commissioning couple themselves. So you might have a commissioning couple. The standard example would be a married couple. Surrogacy is most often availed of by heterosexual married couples. You might have a married couple where the wife is unable to carry a child to term. However, she can provide her egg and the husband can provide his sperm to form the embryo that will be implanted in the surrogate. So in an example like that, you have what we call gestational or host surrogacy, that the surrogate hosts their genetic material for 9 months. And that is what part 3 of the general scheme was proposing to regulate here, that Ireland would regulate gestational surrogacy. The surrogate could never use her own genetic material, but she would act as the host of the genetic material of others. What it proposed to do was that part 3 would have enabled the intended parents of a child born via gestational surrogacy to apply to the court for a declaration of parentage once at least one of them was genetically related to the child. So basically the intended parents, once the child was born, could have applied to the court for a declaration of parentage, transferring parentage from the surrogate, the child's mother at birth, to them. However, the consent of the gestational surrogate was essential, and this is where I see the problem with the proposals. Her consent could only be dispensed with if she was dead or untraceable. So essentially, in order for this transfer of parentage to work, the gestational surrogate had to consent to the intended parents making the court application in the first place. You might say, well, what if she didn't consent? I'm going to come to that in a moment. What was the policy rationale for this? Well, documentation released to coincide with the general scheme stated that this is a protective measure so that the surrogate cannot be forcibly coerced to transfer her parental responsibilities to the commissioning parents. I don't like to think of anyone being coerced to transfer pretty much anything, but we're talking here about a gestational surrogate who in many cases will be carrying the genetic material of both intended parents. It wouldn't be at all unusual for her to be carrying an embryo formed from the sperm and egg of both of the intended parents. So why allow her this protective measure preventing her from being coerced into transferring her parental responsibilities, especially if we consider this from a child-centered perspective, which is what I would hope to do in the next 15 minutes or so. Think about the best interests of the child here. If a gestational surrogate has carried the child of intended parents and that child is born, it is the child genetically of the intended parents, then why should she not be, in a sense, required to hand that child over to its intended parents for the sake of the child, for the best interest of that child. We'll come back to that in a moment. I think a rationale like that now might be more understandable in the case of a traditional surrogate who uses her own eggs and is, of course, the genetic mother of the child. But in the case of a gestational surrogate, many of us here today will know that a gestational surrogate has no genetic connection to the child. However, understandably, her behaviour during pregnancy can, of course, influence the child's development, such as her diet, for example. So it just seemed like this was leaning far too much in favour, I suppose, of the gestational surrogate as opposed to the child, part 3 of the general scheme. As I say, if you consider that surrogacy is predominantly availed of by heterosexual married couples, both of whom, in many examples, might be the child's genetic parents, having both provided the genetic material, then allowing the gestational surrogate, who has acted as a host surrogate for the 9 months, to have this, I suppose, right to keep what is genetically and maybe essentially then someone else's child, seemed to me a little absurd. I'm going to explain why this proposal, if enacted, could have fallen foul of the Children's Amendment, Article 42A of the Constitution, which was inserted just last year following a number of challenges, as I'm sure we're all aware of. I'm also going to talk a little bit about the married family that is protected under Article 41 of the Constitution. So, Article 42A1 then, we might be familiar with this. It provides that the state recognises and affirms the natural and imprescriptible rights of all children and shall, as far as practicable, by its laws protect and vindicate those rights. So children are now expressly protected under the Constitution. The state is going to protect and vindicate those rights of the child. The state is affirming those rights, recognising and affirming those rights that already exist, and it has to protect and vindicate those rights. Oren Doyle and Estelle Feldman have pointed out that Article 42A1 thus places the natural and imprescriptible rights of the child front and centre in any future legislation we might be proposing in relation to surrogacy. Jeffrey Shannon has pointed out that Article 42A1, under that provision, a child may enjoy what we call a natural constitutional right to family life. So the child, if we accept he or she has a natural constitutional right to family life, but then we might also accept that a child born to a gestational surrogate has a natural constitutional right to family life with whom? With his or her genetic parents, or maybe one genetic parent in some cases. The presumption, as reiterated quite forcefully by the late Justice Hardiman in N and HSE there in 2006, the presumption mandated by our Constitution is a presumption that the welfare of the child is presumptively best secured in his or her natural family. The child has a right to the nurture of his or her natural family where that is possible. Of course, we appreciate that children are not always able to be cared for by their genetic parents. It's not always possible. We know that genetic parents have the right to abdicate their parental responsibilities by placing a child for adoption or in the care of the HSE for a whole host of reasons. That children don't always have this right to the natural family, the genetic family, but where possible, the child does have that right, as the Constitution prescribes. So going back to our example then, if a future case of conflict arose between the gestational surrogate, who's not going to consent to the making of the order transferring parentage to the intended parents, conflict arises between her and the intended parents, well then surely Article 42A would be brought into play, and something like Part 3 of the general scheme could have been placed under a constitutional spotlight and might not have fared too well. Why? Well, you could argue that by refusing to consent to the transfer of parentage, the gestational surrogate, by retaining custody of the child, is denying the child its right to the nurture of its genetic family, and that is possible. The example I'm talking about is your common surrogacy example, where the genetic family are waiting in the wings to take the child once born. That is the usual post-birth arrangement. So it seems to me that proposals that allow a gestational surrogate to withhold consent to a transfer of parentage order could possibly be constitutionally unsound, and that is why I'm going to advocate a little bit later on a pre-birth approval model for Ireland. So MR then and on Thor Clorahor, we all know of that case. It's the infamous surrogacy case that was appealed all the way to the Supreme Court. And in that case, Justice Clark made it very clear, almost cautioning the Oireachtas, that within constitutional bounds, it is largely a question of policy for the Oireachtas to determine the precise parameters of assisted reproduction legislation. But he does caution them. They must do this within constitutional bounds. So although we know the Supreme Court in MR did give the Oireachtas a wide degree of latitude to regulate surrogacy in the future, we all know that the Oireachtas has to act within the parameters of the Constitution. So I think that's very important, what was sent out there, that they must act within constitutional bounds. We know that in cases of dispute, so if, as I say, a dispute arose between a gestational surrogate wanting to hang on to someone else's child and the intended parents, we know that the Irish Superior Courts, the Supreme Court in particular, almost always comes down on the side of the family, usually the genetic family, the married family. We know from cases of dispute like Re JH, N and HSE itself, cases of dispute between prospective adoptive parents and the child's biological parents. We know in cases of dispute between the married family, the married biological parents, and the state itself, Northwestern Health Board and HW. We know in cases like that the state, the courts, the Supreme Court, will almost always come down on the side of the constitutional family. And indeed, in all of those cases as well, the genetic family. We also know that genetics are so important to the Irish Supreme Court that in the case of MacD and L, the court came down on the side of genetic parentage there as well. So genetic parentage, hugely important to the Irish Superior Courts. Indeed, in the case of Re JH, Chief Justice Finlay stated that a child of married parents enjoyed the right to protection by the state of the family to which it belongs. So just bringing in Article 41 here then for a moment, where we know the state pledges itself to guard with special care the institution of marriage on which the family is founded and to protect it against attack. Would the state be protecting the married family if the child in this instance is a child born to a gestational surrogate, but a child of genetic married parents? Would the state be protecting the family to which the child belongs by allowing the gestational surrogate to walk away with their child? I think not, and that concerns me. So as I say, genetic parentage, hugely important in the Irish Superior Courts. Case of dispute like this, I really think the Irish Superior Courts, looking at it from what I would hope a child-centric perspective, would say that it is probably not in the best interest of the child to allow the gestational surrogate to have this, what is pretty much, it's the same in the UK, it's a blanket dispensation to keep the child if she refuses to consent to a transfer of parentage or a parental transfer order, whatever it might be. This type of dispensation arguably does deny the child its right to its natural constitutional right to family life with its intended, in the example I'm giving, possible genetic parents. It also denies arguably the family, not denies them anything, it is an attack perhaps on the married family unit to allow a gestational surrogate to keep the child of married parents. That might also go for same-sex married parents nowadays, that they could invoke Article 41 claiming, we entered into a surrogacy. This is assuming legislation like this comes to fruition, which I hope it won't, but if it did, it's what they have in the UK, and the gestational surrogate tries to walk away with the child of same-sex married parents. Okay, only one of the men in the same-sex married family can be the genetic father of the child, obviously, but he has not only genetics on his side, he and his partner also have their constitutionally protected family on their side since late last year, because same-sex marriage is now provided for. So a lot of arguments, constitutional arguments, sort of indicating that a blanket dispensation to a gestational surrogate to keep someone else's child by refusing to consent might be contrary to the Irish Constitution as it currently stands. And that is cause for concern. It should be cause for us to rethink perhaps the model we might like to introduce here in Ireland. So as we know, those provisions were deleted in September 2014. The revised general scheme of the Children and Family Relationships Bill was published then, and the then Minister for Justice, Frances Fitzgerald, informed us that the provisions had been deleted because surrogacy was a complex issue, required more consultation. She spoke about the need to balance constitutional rights, which I found particularly interesting, and I'm really glad that she was very aware of that. I would entirely agree with the decision not to go ahead with surrogacy legislation at that time. So what is the alternative, you might say? The model that is in place in the UK and elsewhere is a post-birth parental order model, which usually allows the surrogate to withhold her consent to the application for a transfer of parentage. That model works pretty well elsewhere. We have seen that it has some glitches in Kirsty's paper earlier. But here in Ireland, we have to remember that we have the written constitution not only protecting married families and quite recently same-sex married families as well, constitution also expressly protecting children's rights. And that is why we have to look at this from a children's rights perspective when introducing surrogacy legislation here in the future. The alternative, I would argue, is a pre-birth approval model. So how the pre-birth approval model, which I believe might be a more constitutionally sound alternative, how it works is this. It operates, I should point out, in certain states in the US, such as California and New Hampshire, and closer to home in Greece. And I'm actually quite taken with what I see as the simplicity of the Greek model, so I'm going to discuss that model in particular for the next few minutes. The Greek model is instructive because it involves court approval of a gestational surrogacy agreement prior to the implantation of the embryo in the clinical setting. So prior to treatment ever going ahead, prior to the arrangement ever being put into place, the court approves the arrangement and quite methodically approves the arrangement. Once the court has approved the surrogacy arrangement and given permission for treatment, there is then a statutory presumption of maternity and a corresponding presumption of paternity in favour of the intended parents as soon as the child is born. So once the child is born, its surrogate mother will never be its legal mother. Its legal parents will be, from birth, its intended parents. It provides the intended parents, this model, with a high degree of certainty in relation to their parentage, and there is no need for them to worry about a post-birth parental order being withheld because of the surrogate's refusal to consent. The intended parents, if both intended parents are a married couple, this approach, I would argue, could help to prevent an attack on their constitutional family by, again, a non-consenting gestational surrogate following the child's birth. From the child's perspective, I would argue that this model protects its natural constitutional right to family life with its intended and, in many cases, or certainly an appreciable number of cases, its genetic married parents. This is all ensured pre-birth. So before this child is ever born, its Article 42A natural constitutional right to family life is ensured prior to its birth. Its right to a family life with its genetic and perhaps married parents. The child, as I say, will only ever have one legal mother, and there is no need for any post-birth judicial proceedings to transfer parentage as well. Indeed, as we've seen earlier, one of the reforms recommended by the Surrogacy UK Working Group on Surrogacy Law Reform is pre-authorisation, so that legal parenthood is conferred on intended parents at birth in the United Kingdom. So this model is gaining traction. Deirdre Madden argues, and I would agree, that the prioritisation of the best interests of the child in almost all surrogacy cases will be to be regarded as the legal child of its intended and in some cases, genetic parents from the moment of its birth. To close, I suppose I would say we must remember that the state appealed the MR decision to the Supreme Court, seeking the, restoration or entrenchment of the mater semper certa est principle, the mother is always certain, i.e., at birth, the mother is always certain, and the legal mother at birth will be the surrogate mother in this instance, who can then choose whether or not to transfer her parental rights. Given the state's attachment to that principle, as I say, they appealed that case all the way to the Supreme Court, one wonders whether the pre-birth judicial approval model will actually be ruled out here and unlikely to be legislated for. Indications from the former Minister for Health, Dr. Leo Varadkar, are that Ireland is leaning towards an altruistic model for surrogacy, which is likely to view the surrogate mother as the legal mother at birth. And it was recently confirmed to me by the Department of Health and the Secretary General there that its officials are currently involved in drafting legislation. So the department is working on surrogacy legislation at present. I suppose to close, I would say that we can only hope that whatever surrogacy model is being prepared, the department is truly cognizant of the best interests of surrogate-born children, and that any proposed legislation will reflect the principles, rights and obligations contained in the Children's Amendment, Article 42A. Just before I finish, I should point out, you might think you're giving a narrow example there of, where the child's genetic parents, both of them are the genetic parents having provided the sperm and the egg, and perhaps both married as well, gestational surrogate. Actually, that's a common enough example. There are many surrogacy cases where they both provide the genetic material, and you might say, oh, but look, that one case ever arising, giving rise to constitutional challenge. Well, I would just say to you, cases like McD and Dell, maybe a decade ago we might not have envisaged a case like that arising, or even the MR case itself. So I would say nothing is beyond the realm of possibility. Thank you for your time.